Hi, welcome to the third lecture on the freedom of speech, where we're going to be taking a look at symbolic speech. So, in this lecture, we're going to define symbolic speech, and then we're going to talk about two cases that the Supreme Court hears that deal with the issue of symbolic speech. So, we're going to look at the case United States v. O'Brien, which has to do with the burning of the draft cards during the Vietnam War. And then we're going to look at a case from 1989, Texas v. Johnson, that looks at the burning of the American flag. So let's get started. When it comes to symbolic speech, we know that the First Amendment protects speech and the press. But the question is does it also protect, does the First Amendment also protect expressive action or conduct? And so in earlier lecture this week, we talked about, and we know the answer to the question is yes, that the court does extend the First Amendment protections to expressive action and conduct. We also talked about examples of expressive action or conduct. Sit-in, wearing an armband, and in these two cases, burning a draft card or burning the American flag, all of those are examples of expressive conduct. And so, as we know the answer about whether or not the First Amendment protects symbolic speech, the answer is yes, that expressive conduct can qualify as speech. However, that doesn't mean all expressive conduct is protected. Not all speech is protected, right? We learned about that in another lecture this week, right? Harassment, libel, obscenity, those are not protected. And, so not all expressive conduct is protected either. So your textbook uses the example of assassination. Killing a government official is definitely expressive conduct. You're basically saying that you don't like this president or you don't like this member of the Senate or whatever. But clearly, assassination is not protected speech, even though it is expressive conduct. So we know, like many liberties, that expressive conduct can be regulated, and it is regulated by the government, and those kinds of regulations are sometimes considered constitutional. But as we're going to see in these cases, that sometimes government efforts to forbid expressive conduct is not constitutional. I do want you to keep in mind that expressive conduct may be more subject to government regulation. In other words, that government regulation, it might be seen as allowable by the courts on expressive conduct due to the nature of expressive conduct, right? And so you're going to see in these cases that you're going to be reading is that the court will consider the impact of the expressive conduct, right? And so they may, and as we know, expressive conduct like a sit-in, has an implication. Like if you're sitting in a public place, you're not just expressing yourself, but you also are impeding the access to a public space that people may want to get into. Burning something can have implications for the safety of others or for property as well. And so keep those things in mind when you are reading the decisions in these cases. The first case that your textbook examines having to do with symbolic speech is United States versus O'Brien, and it's a case from 1968. And this case is about burning draft cards and whether burning a draft card as a form of expression is protected by the First Amendment. And that picture there from your textbook is David O'Brien and three of his friends who are burning their draft cards at the courthouse in South Boston. Now, the backstory on this is that following World War II, in 1948, Congress institutes a peacetime draft. And so they pass a Selective Service Act. And that this law mandates that all male citizens over the age of 18 must register for the draft, and that furthermore, they must carry a small white draft card with their draft information on it at all times. Okay, so you've got to register for the draft, but you also have to have your draft card with you at all times. Now, as we know that the Vietnam War is taking place during this time period in the 1960s, and people start protesting the war and they start protesting the draft. And as a part of anti-war protests, men who are eligible for the draft would burn their draft cards, basically expressing their opposition to the war. Now, in 1965, in response to these anti war protests, Congress they amended the Selective Service Act to include a no mutilation provision into that 1948 law, basically making it a crime to willfully destroy your draft card. Okay. And so the law was changed to say that, hey, protesters, if you burn your cards, then you are violating federal law. David O'Brien is a pacifist. He opposes the war in Vietnam. He refuses to kill, and as such, he opposes the draft. And he wants to persuade other people to oppose the war and resist the draft as well. So on March 31st, 1966, in order to express these beliefs, that he and three other people, they go to the courthouse in South Boston and they burn their draft cards. And an angry crowd gathers. The FBI is actually there because they had word that this protest was taking place. The FBI takes O'Brien and the three others into the courthouse to protect them, but also to question them about their actions. And the FBI agents tell O'Brien that he's violated the Selective Service Act because he willfully mutilated his draft card. He was arrested, he was charged, tried, and convicted, and sentenced to 6 years. And so this case is O'Brien challenging that conviction and asking the Supreme Court to overturn his conviction. The argument being that his actions of burning the draft card are expressive conduct and that they're protected by the First Amendment. So let's take a look at some critical thinking questions about this case, and then next, let's look at how the court ruled. Okay, the first thing I want you to think about with this case is about the expressive conduct and the purpose of the expressive conduct. So when O'Brien is burning his draft card, is he trying to communicate a message, right? Is in burning the draft card, is he trying to express himself? Is he trying to communicate something about the war? Okay. And another thing, so what ideas or message is O'Brien hoping to express by burning his draft card? Another thing I want you to think about is, can O'Brien express this idea? So I think it doesn't, it's not hard to conclude that the message that he's trying to communicate is that he is against the war, that he's resisting the draft, that he refuses to kill as a pacifist, and he's encouraging other people to do the same thing. I guess another question I want you to think about is communicating that message dependent upon burning the draft card? Could O'Brien express this idea in an other way than burning the draft card? Or is there something about burning the draft card that really enhances or magnifies his message, right? Making a speech about resisting the war is one thing, but engaging in that expressive conduct, does that actually allow him to communicate and express himself in a way that he wouldn't be able to just by making a speech? The other thing I want you to think about is from the government's perspective. What's the purpose of the no mutilation law? So in the mid-1960s, Congress adds that provision to the Selective Service Act, basically making it a crime to knowingly mutilate the card. Is that no mutilation law, is it related to a legitimate government purpose? Does the government really need those cards in order to make sure that they can draft people into the Vietnam War? Or are they targeting speech because they don't want people to express themselves in the way they want to push back on anti-war protesters? And so do you think this law is neutral? Is it related to a legitimate government purpose? Or do you think it's targeted at a particular expressive viewpoint. The other thing I want you to think about is, does the law targeting O'Brien's effort to freely express himself, or is the purpose of the law related to something other than the expression? And that, that's what I sort of already articulated. I should have put that bullet up before I was going on. And then finally, I just want you to think about, so what do you think if you were on the court? Do you think that the anti-mutilation provision of the Selective Service Act, do you think that violates the First Amendment of the Constitution? Do you think that the First Amendment should protect this expressive conduct, or do you think that the government has a legitimate reason for preventing the mutilation of the draft cards? Okay, so the question before the court in United States v. O'Brien is, does the anti-mutilation portion of the Selective Service Act violate the First Amendment of the Constitution? And as you know from reading the textbook, or as you will read in the textbook, the Supreme Court rules that no, the First Amendment does not protect your right to burn your draft card. And it's a 7-1 vote. So, the vast majority, it's a strong ruling by the Supreme Court. They find that the destruction of the draft card is not a constitutionally protected activity. Now, I will leave it to you to read this, the reasoning in the case, and you might want to consider using this case for your second case brief that you'll be doing that includes the speech cases. But let me just give a quick summary, okay, of the ruling in this. The court says that expressive conduct does not automatically merit First Amendment protection. They basically say that when speech and non-speech is combined, that you just need a sufficient level of government interest to justify regulating the non-speech conduct. Okay, so again, the court is basically saying that expressive or symbolic speech does not get as robust First Amendment protections as more traditional speech. But that doesn't mean that it's completely outside of First Amendment protections. They basically say that government interest can justify regulating the non-speech conduct. And that's how they rule in this case. They basically say that that the government was justified in prohibiting the burning of the draft cards. That the draft card has this information on it that the government needs in order to make sure that they are drafting the right people, or it's a way of communicating where you might go once you are called up for the draft, etc. And so they said that by burning the card, it really does thwart an important government interest and power. And they also say that the law doesn't target expression. We were talking about that on the last slide. They basically say that O'Brien is still more than able to express himself through his speech and through other traditional expressive conduct. Taking away the right to burn your draft card, or taking away burning the draft card, isn't really impinging on his freedom of expression. So that's just sort of a summary. Make sure that you read the dissent as well, but that kind of, and the reasoning of the court, but that gives you an idea of how they ruled in this case. Okay, the next case that we're going to take a look at is Texas v. Johnson, and it is the case having to do with burning the American flag. Now, from the last case, the Supreme Court says that burning your draft card is expressive conduct, but that it's expressive conduct that is not protected by the First Amendment because the government had a legitimate reason for prohibiting the burning of the draft card. What about the burning of the American flag? Do you think that there's a legitimate reason for government to prevent the burning of the American flag? Or do you think that burning the American flag is sort of different than burning your draft card, and that it deserves First Amendment protection? Well, the court has the opportunity to answer this question in 1988. Couple things I want you to keep in mind is that this is an era of relative peace, and so the burning of the flag takes place in 1984, so it's kind of a different time period than the O'Brien case. And also, it's the makeup of the court has changed, that it is a relatively conservative court at this time, with the addition of Justices Rehnquist, Scalia, and Kennedy. So keep those in mind as we talk about this case. Okay, so as I stated on the last slide, this is a case about burning the American flag and whether a state law prohibiting the burning of the American flag is constitutional. And in the photo there, you have the Gregory Johnson, the person who burned the flag, and his lawyer. So a little bit of a backstory on this. So the state of Texas has a law on its books, and it's called the Flag Desecration Law. And this law prohibits the defilement of the American flag. That any person who knowingly or intentionally harms, abuses, desecrates, or damages the flag can be charged with a crime. Okay, so engaging in the basically the willful desecration of the American flag can be charged with a criminal act. That this wouldn't include like burning an American flag, as it gets older, and a proper disposal of it. I mean, this would be where you are, burning the flag like Gregory Johnson does, which we'll hear in a second. And Texas felt that they needed this law in the books because they argued that when people burn the American flag, that it really upsets a lot of people, and they kind of viewed it as fighting words. Like the only purpose of burning the flag is to like make people really angry and to bring about a fight. So they put this law in the books because they wanted to make sure that there that breaches of safety, the breaches of the peace, they wanted to prevent the breaches of the peace that they thought would come with burning the flag. They also had the flag in the book, though. They said that they needed it because the American flag is an important symbol. It's a sign of national unity, and therefore the government has a legitimate interest in protecting this symbol of national unity. Now, Gregory Johnson felt otherwise. So Gregory Johnson, as you might tell from his shirt, I don't know if you can see it there because my head's kind of in the way, but he's got, a red communist star in his shirt, and it looks like he has a weapon as well. So not surprisingly, Gregory Johnson is a member of the Revolutionary Communist Youth Brigade, and he is a political activist. He is opposed, as a communist, he is opposed to the Democrats and the Republicans. But in this instance, for this case, the facts of this case is that he was at the Republican National Convention in 1984, protesting the re-nomination of President Reagan. And about 100 people were with him, and they marched through the streets of downtown Dallas. That's where the convention was taking place. One of the demonstrators stole a flag off of a targeted building. So they were protesting Reagan and the Republican Party, but they were also protesting capitalist corporations. And so one of the corporations, they went, they're flying a flag, and they took the flag, and then they marched down to Dallas City Hall, and they doused the flag with kerosene. They set it on fire, and they chanted, "America, the red, white, and blue, we spit on you. You stand for plunder. You will go under." Gregory Johnson is no one is hurt at the rally. Okay, so they burn. People are like standing around in shock. That some of the bystanders are really offended by the burning of the flag. It's reported that one witness picks up the flag, and that they properly bury it in their backyard because they are so like upset by it. Gregory Johnson, not surprisingly, was arrested for violating the Texas flag desecration law. He's charged, convicted, and sentenced to a year in jail and a $2,000 fine. And Gregory Johnson objects to this conviction, saying that the burning of the American flag is protected by the First Amendment, and the Texas flag desecration law violates his First Amendment rights. So let's take a look at some critical thinking questions, and then let's look at how the court ruled in this case. Okay, so here's some things to think about as you're reading and thinking about the case. So just like with O'Brien, what idea or message is Johnson hoping to express by burning the flag? Do you think that he is just trying to rile up the crowd and start a fight? Or do you think that, why would somebody burn the American flag? Is it because they hate the United States? Is it because they're trying to send a message about the United States, some dissatisfaction they might have with the United States? I mean, what's the message that you think he's trying to communicate? And also, just like with the O'Brien case, can is there something about burning the American flag that just really couldn't be captured in words, right? And so, is can Johnson express this idea, the idea that he wants to communicate in a way other than burning the flag, right? Like, what if he just had like a picture of a flag, right? And then he burnt that. Would he be able to communicate it? Or is there something about burning the actual American flag that allows him to express himself in a way that he would be unable to express himself with words? Now I want you to think about, is there a difference between burning a draft card and burning the US flag? And are these important differences to consider in this case? And so, what was the purpose of the draft card, right? And I mean, in the O'Brien case, they talk about how there's important information on the draft card that without it, it's difficult for government to actually like draft people. And I'm not sure I agree with that. I mean, that certainly wouldn't be the case today because we've got computers and stuff. But you could sort of see that the draft card plays a particular purpose. What about the American flag? Does the American flag serve a particular purpose? I mean, the state of Texas said that it represents national unity, but I guess does the American flag does it have multiple like meanings? Does it have multiple purposes, right? And so keep that in mind as you are thinking about this case. Do you think that burning the flag is fighting words? And we know that fighting words aren't protected. Is the only purpose of burning the flag to bring about a fight, or is there an expressive purpose beyond bringing about a fight to consider? And also, what do you think is the purpose of the Texas desegregation law? We talked about that on the last slide. Do you think it's related to a legitimate government purpose? Also, another thing to keep in mind is it viewpoint neutral, right? I mean, is by saying you can't burn the flag, saying that burning the flag has one meaning and one meaning only, and that expression is what is being targeted. And then finally, what do you think? How would you rule in this case? Do you think that the Texas flag desecration law violates the First Amendment of the Constitution? Do you think burning the flag should be protected by the First Amendment's freedom of expression clause? So the question before the court in Texas v. Johnson is, does a state law that prohibits the burning of the American flag violate the First Amendment's freedom of expression? And in a closely decided case, even with the conservative court, in a 5-4 vote, they find for Johnson. They say that the Texas law is a violation of the First Amendment's freedom of expression clause. So again, this is a great case, and I really encourage you to read the reasoning and really to, read the dissents as well. I mean, you've got some really vibrant dissents that are going on in this case. And I swear to God, I've been teaching this for many years, and every time I read the reasoning in the case, I can never decide really where I am on this case. Okay, am I with the majority or am I with the minority? So I really encourage you to do that. But in summary, just sort of an overview of the reasoning is that they say that, just like with O'Brien, that burning the flag is expressive conduct and that therefore it implicates the First Amendment. And then they look at the reason that the state has for the law. They say that they have the law because they want to prevent breaches of the peace, and that they also have the law because they want to preserve the flag as a national symbol. The court says that burning the flag does not constitute fighting words, and it doesn't constitute like that it's going to bring about a fight or breach the peace. And so they throw that out. They say that reason for the law does not stand their scrutiny. Then they turn to the other part of it, that you need to preserve the flag as a symbol of national unity. And that they basically conclude that the state's interest in preserving the flag to preserve a symbol of national unity is related to suppressing expression. They basically say that for some people, the flag represents a sign of unity, but for other people, that they find the flag as representing something completely other, that they don't see it as this beautiful symbol of national unity and national pride, but they might see it as a symbol of corruption or of immoral action or of abhorrent behavior. And while you may not agree with that, says the court, that you may not agree that that is what the flag represents, that by suppressing that viewpoint, that it's basically viewpoint discrimination. And they basically say that they are saying that that you can express your love for the flag, but you can't express your dissatisfaction with the flag. And so they basically say that the bedrock principle underlying the First Amendment is that the government may not prohibit expressions of an idea simply because society finds the idea itself offensive or disagreeable. So you might not agree with what Gregory Johnson is saying, but under the First Amendment, he has a right to say it, and he has a right to say it via his expressive conduct of burning the American flag. Well, those are two really fun cases, and there are more fun cases in the second half of the chapter dealing with freedom of speech. And so keep in mind that the midterm only includes the first half of the chapter on freedom of speech, and so make sure that you look in the canvas to see which pages you're responsible for. But after the midterm and after spring break, we continue with part 2 of freedom of speech. And if you liked these cases, you're going to love what's coming after freedom in the second half of this chapter. We're going to be taking a look at hate speech and the landmark case about Westboro Baptist Church. We're going to be looking at student speech, about whether or not you check your First Amendment freedom of speech rights when you walk through the school door. The answer is you don't, but the court treats student speech differently than it treats speech in other contexts. We'll be reading the Bong Hits for Jesus case, where a guy holds up a banner at a school event saying Bong Hits for Jesus. We're going to take a look at the right to not speak, and then we finish out this chapter after spring break by looking at the freedom of association, which is also included in the First Amendment. And so we're going to be looking at the landmark case about the Boy Scouts of America and whether or not the Boy Scouts of America can define their membership in a way that denies people membership in the Boy Scouts based on their sexual orientation. Okay, that's it. And I will talk to you again after spring break, or actually while we prepare for our midterm exams. Okay, talk to you later.